I'm Mark Scarberry. I teach here at Pepperdine, and thanks to all of you. You hung in there. This is our final panel of the day. We have a great group. Actually, my name is Richard Posner, but maybe I ought to put that away. Okay. Again, we have a great group. We're going to try to keep quite a bit of time at the end for Q&A. So I'm going to introduce all of our panelists, and then they'll just come up. I think that's probably the most efficient way to do it. So our first speaker will be Richard Friedman, the Arlene and Alan F. Smith Professor of Law at Michigan Law School, expert on evidence and Supreme Court history, one of the few scholars developing a new field, sports and games as legal systems. So we have a new sports center here, so that'd be kind of interesting. He's the general editor of the new Wigmore, and Wigmore, the old amazing treatise that it's a multi-volume treatise on evidence, and his textbook, The Elements of Evidence, now in its 4th edition. He's the co-author of Park and Friedman's Evidence, Cases and Materials, now in its 12th edition. Okay. Second, we're going to have Professor Jason Mazzone, who's a professor of law, the Lynn H. Murray Faculty Scholar at Illinois at Urbana-Champaign. He's also the co-director of the program in Constitutional Theory, History, and Law. His primary field of research and teaching is constitutional law and history. Works principally on issues of constitutional structure, institutional design, particular focus on relationships between structural arrangements and individual rights. I think Madison would like that. Received his undergraduate and law degrees from Harvard, master's degree from Stanford, a master's degree and doctorate from Yale. Our third speaker is going to be David Orentlicher, who's the Samuel R. Rosen Professor of Law, co-director of the William S. and Christine S. Hall Center for Law and Health at Indiana University School of Law. He's an expert in constitutional law and health law, and we just heard some discussion of the Affordable Care Act cases. I graduated from Harvard Law School and Harvard Medical School. Author of Matters of Life and Death, co-author of Healthcare Law and Ethics. His most recent book, Two Presidents Are Better Than One, The Case for a Bipartisan Executive, draws on his experience as a former state representative. We actually have a politician here to help us learn about legislation. From 2002 to 2008. He joins the faculty at UNLV at the William S. Boyd School of Law this fall. And finally, Eric Siegel, the Kathy and Lawrence Ashe Professor of Law at the Georgia State University College of Law, author of the book Supreme Myths. We've heard about myths today too, haven't we? Why the Supreme Court is not a court and its justices are not judges. He's working on the forthcoming book, Originalism as Faith, for Cambridge University Press. His articles on constitutional law have appeared in, among other journals, Harvard, Stanford, Northwestern, Washington University, and Cornell Law Reviews. And it's my great pleasure to introduce this panel, and we'll start with Professor Friedman.
Thank you very much, and my thanks to everybody at Pepperdine for organizing this wonderful conference, and I'm delighted to be a part, and thank you. And thank you for staying to this point in a long day on a Saturday. I'm happy, and my apologies to David because it looks I'm you, but sorry, on the screen. I'll try to make several points. One, I think we do have a highly political confirmation process, highly political, not unprecedented, but more than it has been at many other times in our history. I don't think it's a good thing. I agree with Michael McConnell, Akil, or Irwin that good riddance to the filibuster. I don't think that eliminates the problem. I think the only way out is if the Congress becomes and is perceived as becoming less active. And as somebody from mildly, at least on the left side of the political spectrum, I think that would be a welcome development. I think progressives should welcome the development. I have one suggestion as to what could happen to make this happen, but it won't. Okay, so selection is always ideological. The president has to pick, and obviously the president is going to be aware of the ideological orientation of the nominee. I think that's pretty much inevitable. But a politicized confirmation process, and by politicized in this sense, I mean one in which the Senate is less deferential to the president and pays attention to ideology. I don't think that is inevitable. And by paying attention to ideology, I do want to say, I mean, I think obviously there are bounds beyond which we shouldn't have a Supreme Court nominee, an appointee. If a nominee said that apartheid was a good thing, I think we'd say, well, that's just beyond the realm of discussion here, for example. Okay, so it's clear it's a very highly politicized process. Look at what the Republicans did to Judge Garland. Look at the filibuster on Gorsuch. And we can debate about how to characterize the Fordist filibuster, but that was, in 1968, that was the only successful filibuster ever of a Supreme Court nominee. It's not unprecedented, the era that we're in. So in the Reconstruction era, for example, the process was far more contentious than it is now, far more political. It's true that the Senate has never done quite what they did to Garland, but in a way they did something much more dramatic to one of Andrew Johnson's nominees. Well, really, the only one he made. He nominated his Attorney General Henry Stanbury to a vacancy of the court. And what did the Congress do? They eliminated 2 seats to make sure that Johnson wouldn't get that nomination or any other. They restored the seats after Johnson left the presidency. In that period, numerous rejections, largely for highly politicized reasons, which is largely because of a very overheated political environment. The perception of the court as a political institution, principally because of the Dred Scott decision. The justices were expected to be politically motivated, and their orthodoxy was demanded by the Senate. And then slowly, for a variety of reasons, steadily, the process changed and the controversy declined, so that for a period of over 70 years, there was rarely much controversy. Sometimes there was. Between 1894 and 1968, there was only one rejection, and then even after a flurry in those 3 years, it again, until 1987 with Bork, it became, for the most part, a relatively uncontroversial process. 4 Eisenhower nominees sailed through an adverse Senate. John Paul Stevens, nominated by Gerald Ford with a Democratic Senate, a relatively weak president in the sense he was unelected towards the end of his presidency, not the last year, but he sailed through. In 1986, Judge then Scalia won, it was 96 or 98 to 0, which is really remarkable. And then since 1987, it's been far more controversial. But I'll quote 1967, at the time of the Thurgood Marshall nomination, Ted Kennedy said that ideology shouldn't play a role. Background, experience, qualifications, temperament, and integrity should. I happen to think that's right. I mean, it sounds awfully romantic now because I think for a generation that hasn't been what's happened, but I think that's right. I think that the Senate, it would be better if the Senate deferred. Why? I mean, it's counterintuitive. Well, okay, I think as Mike McConnell suggested, political resistance invites retaliation, so it sets up a process where, well, maybe we get ours today, but it's likely to come back to haunt us the next time. The same president will name the replacement, and there's no guarantee. There's a point that Akhil Amar mentioned, that it will be better from an ideological standpoint. David mentioned Hainsworth and then Blackmun and Bork and then Kennedy. But if you look at those carefully, it's tricky. Hainsworth was rejected, and then the next nominee was Carswell, who I think from the point of liberals was worse. So they have rejected him, and then got Blackmun, who at that time appeared to be a very conservative judge. He then drifted left, but at the time of the confirmation, it wasn't clear how that would work out. Bork was rejected. Next nominee was Douglas Ginsburg, who was also very right-wing and considerably younger. Next nominee was Kennedy, who also has, in some respects, drifted left, but he's 10 years younger than he was 10 years younger than Bork, and Bork died something like 10 years ago during the George W. Bush administration. I'm not sure that over the long haul and for the most part, liberals have come out better than for having rejected Bork. Prediction is difficult. Prediction of what a judge nominee is going to do is often very difficult, particularly over the long haul. Sometimes these choices backfire. Also, I think at a fundamental level, if this is the way we're making policy, if you say, you know, it's politics and this is just a different form of politics, it's a weird way of making policy is through Supreme Court nomination and confirmations. It's an awkward style. I mean, when I see TV ads in favor or against Supreme Court nominees, I think, wow. I mean, it's removed from the policymaking. So I think it's odd. I think an aggressive Senate role encourages blandness in the candidates, stealth candidates. Judge Posner, I think, accurately pointed out how the nature of nominees has changed. The court that he mentioned in 1962 was filled with people who had had major, significant careers outside the law, and that kind of nominee seems almost impossible today. It encourages a form of disingenuity that's been discussed several times today. I call it cottonwalling, which is not a wall of stone, but a wall of froth, of fluff, where the nominee refuses to answer questions on grounds that are highly dubious, and which I think knowledgeable observers say that's just not particularly honest. And I think it's just unfortunate that on the threshold of getting onto the Supreme Court of the United States, this is now what we expect our nominees to do. I think that's unfortunate. And then fundamentally, I think it encourages a political perception of the court. Now, yes, I know that the court is political in the sense that the justices are ideological, but the court has a distinct function from the political branches, and it's important that it have that distinct function, both in an active sense. We want the Supreme Court to enforce minority rights and not simply say, well, I think that this should be the rule, but if the Constitution commands it, if whatever materials there are that determine law, that should be the way that the conclusion that the justice comes to, even if it's unpopular. Okay, and also on the passive side, a justice should say, if this is within the power of Congress or within the power of the state legislature, it's not my job to knock it down if it is within constitutional power. And I think the politicized perception of the court tends simply to dull those distinctions and really mislead the public. So I can preach, but what remedy? As I said, I think good riddance to the filibuster. It should be easier for the majority, for a president, if the Senate is of the president's own party, to get nominees through. But there's an oddness here then that it then puts it all into the presidential election and tends to make the presidential election in significant part about nominees to the Supreme Court, which I think is unfortunate. Term limits, I thought Akil made a very good presentation. I think there are advantages in evening out the nominations. I don't think strategically timed retirements are all that big a deal, because I think they happen less frequently than people realize. I mean, think about William Douglas retiring and giving the nomination to Gerald Ford, who had tried to impeach him. I think also the average age of nominees would creep up now, so it would mitigate one of the benefits that Akil pointed to, and there would be more confrontation battles. I think the only real solution ultimately is, in effect, to lower the temperature. If the court itself would become and would be perceived as less activist than it is. And I think progressives should realize that recently and over history, they've lost a lot more than gained from the court's anti-majoritarian decisions. And some decisions which they barely got through, they would have lost more. Take the 11th Amendment decisions, restraints on the commerce power, limitations on the Affordable Care Act, one vote short of falling altogether, but significant limitation on Medicaid expansion. Shelby v. Holder, which knocked out effectively one key part of the Voting Rights Act. Citizens United, limitations on affirmative action. Maybe you can mention here Bush v. Gore, that wasn't a limitation on democratic decision-making, but it was a limitation on the state court. I think if you put that against counter-majoritarian decisions on the left side of the spectrum, which mainly went along with the flow of changes that were likely to happen anyway, I think that progressives, and here I've just talked about the last 20 years, if we went further back before the Warren Court, it's just absolutely clear how historically the court's counter-majoritarian decisions have almost all been on the right. So I think if the court were and were perceived as less activist, it would lower the temperature, encourage a less politicized decision-making process, and that would be all to the good. So how do you get there? It's unlikely to happen, but I will say there's one decision in particular, which hasn't been mentioned all that much today, that if it were reversed, I think things would change, and that's Roe v. Wade. I think there's been no comparable decision in history in terms of the amount of passion that it generated over decades. We're nearly a half a century out. Dred Scott would have generated that amount of passion and opposition over decades, but it effectively got overruled by the Civil War, then the 14th Amendment. I think Roe looms over the confirmation process the way Dred Scott did for a quarter century. Roe's lasted longer in a sense. From the progressive point, is it too much of a price? Actually, I think I'm not sure it's a price at all. I think the existence of Roe was, and Doug Kmek, I think, referred to this. I think it was a significant factor in the election of Donald Trump, which, from the progressive point of view, is not a good thing. But he mentioned the evangelical vote and the Catholic vote. And I'm frankly not at all convinced that if Roe were overruled, access to abortion over time would be worse off, or significantly worse off. How could that be? Take the fact that it's access is not good today. If the matter did become a political matter, most people favor a right to early term abortion. I think with the political structure that we have, they're more highly motivated voters on the anti-abortion side who let that vote change the presidential vote. But if it were an election fought out over, elections at the legislative level fought out over abortion, I think the Democrats would do much better, and there would just be an enormous flood of money. We've seen this already with the election of Trump. There'd be an enormous flood of money into pro-choice groups, which I think would alter the political landscape and would also make it easier to provide abortion access where it wasn't readily available. Thanks very much.
Great. So thank you so much. Thank you all for being here. I was originally on a different panel, so if anything I say sounds irrelevant, that's why. So I have a sort of descriptive point, and then which is really kind of a complaint, and then a proposal, and it actually does pick up a bit on some of the things that Richard Friedman had said a moment ago. So the complaint, the descriptive part, is that the Supreme Court does too little and it does too much. It does too little because it hears very few cases, and the cases it does hear are probably not representative of the range of cases that are decided in the state courts or in the lower federal courts, let alone representative of the wider range of interactions, millions of them, between government and individuals that don't result in litigation. It does too much because from this small set of cases, they're probably not representative. The Supreme Court decides what the Constitution, the U.S. Constitution, means for everyone else, and lower courts and other governmental actors, and indeed all of us, are supposed to accept the court's interpretations and rulings. This seems to me bizarre, but more importantly, it has a number of significant costs. And I want to talk specifically about the Constitution and about individual rights, but I think the problem extends beyond that particular context. So, for one thing, lodging authority over the meaning of the federal constitutional rights in the Supreme Court, or a single court at the top, is bad for the court. Concentration of power helps explain, I think, the increased politicization of the Supreme Court in the modern era and the emergence of the Supreme Court as an election, as a key election issue. The Supreme Court reviews a very small number of cases each term, and when it decides an issue, it might not return to that same issue for maybe a decade. So the stakes then in every decision from the court are very high. If you win at the court, you win big. If you lose, you lose big, because the ruling applies everywhere and is not likely to be overturned anytime soon. And so at the same time, who sits on the court then it becomes immensely important. So whether it's a valid assessment or not, there's a strong sense, and I think we've heard much of this expressed today, that one or two changes in membership could alter how the court decides issues before it, and this has big implications for the entire country. So that's the first problem. Second problem is, I think, this sort of consolidation of power at the top reduces rights overall. So the justices understand that they are setting rights when they interpret the Constitution for a diverse nation, that those rules impose costs upon state and local government, and it's better to postpone generally, deciding more than is necessary to dispose of the case at hand. And there are examples are everywhere, and they cut across the political division. So you get, say, cases like Gideon versus Wainwright, right to appointed counsel provided by the government. And this is something Erwin Chemerinsky has written a lot about. The quality of counsel is often extremely bad. And so, yes, you have the right on the one hand. On the other hand, sometimes you would be better off than the lawyer that you actually get. Or you might take D.C. versus Heller, Chicago versus McDonald, the Second Amendment cases, where the court interpreted the Second Amendment and has, at this point, not gone any further than those cases, quite modestly, in a way that basically reflected the views of most members of the U.S. public, possession of a handgun at home for purposes of self-defense, and sort of leaving on the table and raising and making the point that one shouldn't understand those cases as extending into a whole variety of other contexts where you might have stronger sorts of protections. Problem number 3 is that with the Supreme Court kind of deciding everything for everybody, or at least having the last word, you don't get tailoring of federal constitutional rights. So this kind of one-size-fits-all approach prevents tailoring that might actually be quite helpful, right? Tailoring would allow you to match the scope of the right that's recognized to the problem you're trying to solve. So perhaps impose tougher rules, for example, under the federal Constitution where government is more inclined to or is shown itself more inclined to violate rights. And likewise, and this is a fairly similar point number 4, you don't get localized experimentation with respect to federal constitutional rights that could actually be quite helpful. And then the 5th thing is, because you might be thinking, well, there are state constitutions as well, I think this kind of consolidation of authority with respect to the federal constitution has undercut diminished state constitutional law. So it's also a kind of casualty of this trend. There are exceptions. There are some state courts that interpret their state constitutions in different ways, more aggressive ways than does the Supreme Court when it comes to interpreting analogous provisions of the federal constitution. But for the most part, the state courts hew to the understandings of the U.S. Supreme Court. When the state courts are interpreting state constitutional provisions, they basically track what the Supreme Court has said the federal constitution itself requires. So you lose that kind of independence. And there are a variety of reasons for this. Litigants tend to press arguments in terms of federal rather than state constitutional rights. You all are trained in nationally oriented law schools. I suspect you've heard much more about the U.S. Constitution in this building than you have about the California Constitution. Other sorts of reasons as well. And one of them is just the sheer fact that the state courts are so busy kind of implementing the rulings that are issued by the U.S. Supreme Court. They kind of lose the capacity to invoke more aggressively the state constitutional provisions. And so the federal constitution then ends up being a kind of ceiling where it really should just operate as a floor. Okay, so that's the complaint. Now, how about remedies? So one remedy is to have the Supreme Court decide many more cases, more run-of-the-mill cases, more ordinary cases. That doesn't seem very likely to me. So the other option is to reduce the significance of the court's decisions. And we can do that by, and this is the title of my paper, dispersing constitutional authority. And there are different ways to achieve that. But here's one that has a historical precedent. So from 1789, with Section 25 of the original Judiciary Act, until 1914, the Supreme Court lacked statutory authority to review state court cases that upheld constitutional claims against state government. So there are no cases prior to 1914 in which state government was able to go to the Supreme Court on the ground that the state court had ruled against it on federal constitutional grounds and asked the Supreme Court to correct that decision. The court's jurisdiction as a statutory matter ran in only one direction. So this meant that the state courts had some degree of independence in one direction to decide the meaning of the federal constitution without interference or any risk of being reversed by the U.S. Supreme Court. So, a proposal is let's resurrect that. And you could do it with a statute, or we have a historical precedent. You could also do it with the court announcing itself, simply not granting review in cases from state courts at the behest of state government, raising federal constitutional issues. And the easiest set of cases, I think, in which you might do this would be criminal cases, because you don't have to alter then removal rules, which would sort of which would be a kind of runaround to this idea. And there isn't a risk of competing rights on both sides, which also might present a problem in other sorts of cases. The state's always on the other side in a criminal case. So no review of federal constitutional issues, at least in state criminal cases, at the behest of state government. You might think, well, that's a kind of strange idea. But two justices have actually embraced something along these lines. Justice Stevens, of course, now retired, but more recently Justice Sotomayor. Justice Stevens pushed this idea for a long time, first beginning in a case called Michigan versus Long in 1983. He said, the Supreme Court just has no reason to intervene in criminal cases which the only alleged error is that the state court arguably overprotected a defendant's federal constitutional rights. So it went beyond what we thought the federal constitution required, no reason for the Supreme Court to intervene. And he pressed that idea in a variety of cases, argued the court simply should not grant review in those kinds of cases. Justice Sotomayor signed on to one of these opinions in which Stevens said this in 2009 in a case called Michigan versus Fisher. That was her first term on the court, and she went kind of quiet about this issue until just recently. And so I want to mention then two cases in which she's really gotten behind this notion. They're both from the court's 2015 term. First case is Kansas versus Carr. This is a case out of in which the Kansas Supreme Court has vacated death sentences imposed upon 3 defendants on the ground that the jury instructions given at trial violated the 8th Amendment because they failed to tell the jurors that mitigating evidence did not have to be proven to them beyond a reasonable doubt. Right? In other words, it was enough for the jurors simply to be satisfied of the mitigating circumstances. And the Kansas Supreme Court said, well, that's the wrong instruction. They might have labored under the wrong theory, under the wrong standard of proof, that some reasonable beyond reasonable doubt standard actually applied. In an 8-1 decision with opinion by Justice Scalia, the Supreme Court reversed, holding that the Eighth Amendment, as construed by the court in prior capital cases, imposes no requirement that a court instruct a jury that mitigating circumstances need not be proven beyond a reasonable doubt. Justice Sotomayor dissented alone, and echoing Stevens's earlier arguments, she said, "I do not believe these cases should ever have been reviewed by the Supreme Court." She said she saw no reason to intervene in cases like these, and plenty of reasons not to intervene in cases where a state has not violated any federal constitutional right and merely overprotected its citizens based on its interpretation of state and federal law. And so she said, reviewing those kinds of cases prevents the states from serving as necessary laboratories for experimenting with how best to guarantee defendants a fair trial. So a kind of judicial federalism idea. In addition, she said, review of a state court decision where, again, the only alleged error is the state court went further than the Supreme Court would under the federal Constitution, has the effect, in her view, of diminishing rights in general. So she said, explaining that the federal Constitution does not protect some particular right, it's natural to buttress the conclusion by explaining why that right is not very important. So those kinds of explanations risk discouraging states from adopting valuable procedural protections, even as a matter of their own state law. Though the court pretends that it sends back cases like this, one with a clean slate, it rarely fully erases its thoughts on the virtues of the procedural protection issue. In other words, the Supreme Court is putting a kind of thumb on the scale that is probably going to, in her view, preclude even adoption of more aggressive protections of rights as a matter of state law. She also warned against the risks associated with the Supreme Court issuing constitutional decisions in cases that might be representative. And essentially, she said, it's a horrible crime. My 8 colleagues are eager to do something in response, but that presents a problem. And she said, she concluded her opinion by saying, the standard adage teaches that hard cases make bad law. I fear that these cases, because they're probably not representative, suggest a corollary, shocking cases make too much law. So in some error correction in a kind of drastic case may have much broader effects. The second case I want to mention is a case, if you've taken criminal procedure, you've probably read it, it's called Utah versus Strife. That's a case in which you have the police who are conducting surveillance on a house. They've gotten a tip that there's drug activity in the house, but not much more than that. They see a variety of people kind of coming and going, leaving the house after a short period. The officer follows one of the people who leaves the house, stops him in a parking lot, asks for his ID, and then runs a background check. The background check turns up an outstanding warrant on an unrelated issue. The officer then arrests this individual and pursuant to the warrant, and then searches him and finds narcotics and drug paraphernalia. The Utah Supreme Court, this is in Salt Lake City, the Utah Supreme Court holds that the search is and the arrest are fruits of an illegal stop. And the government concedes in the case that the stop in the parking lot violated the Fourth Amendment. The U.S. Supreme Court, again, 8-1 opinion, this time by Justice Thomas, reversed, holding that there was attenuation, that the discovery of the warrant, dealing with independent charges, was enough to break the link between the illegal stop and the drugs that are then found, and then the basis for the conviction. Justice Sotomayor dissented, and here she made, I think, a very important point. She said, context actually really matters in these cases, and this is the thing that the court is missing. And she pointed out that there are lots of places where huge numbers of people have outstanding arrest warrants. And often because of, say, failure to pay a simple traffic fine, a warrant will automatically issue. And so following the majority's logic, that means that that person can be quickly swept into the criminal justice system, prosecuted for other kinds of charges. And she pointed out that this is one of the things that the Department of Justice has been concerned about, and was particularly concerned about in Ferguson, Missouri, when it was investigating there the problems of abusive police practices, tied those practices, at least in part, just to the routine issuance in Ferguson of these warrants for failure to appear at a court hearing, failure to pay a fine for a traffic hearing, and so on. And so large numbers of people in that city were routinely being stopped by the police to find out whether they had a warrant, and then brought into the criminal justice system. And I think most importantly, Justice Sotomayor said, and the Utah Supreme Court has in prior cases been very concerned about this issue in Salt Lake City. And so this is a context, I think the suggestion is, where it makes no sense for the US Supreme Court to impose a one-size-fits-all approach, that you should allow the Utah Supreme Court to impose a stronger rule if it wants in that context, given the history of problems in Salt Lake City and perhaps Utah more generally. So there's one justice, of course, but she's soon going to be amazingly the senior liberal justice on the court. She's limited this idea to criminal cases, but it's not a bad start. This kind of return to the pre-1914 approach, starting with criminal cases, I think would have a bunch of benefits. It would reduce the stakes in Supreme Court decisions involving constitutional rights, make retirements and appointments of justices less momentous occasions than they are today, would protect rights more robustly, would allow for more regular revisiting of constitutional rights, would allow for tailoring of constitutional rights, would produce a greater accountability because state court judges tend to be more accountable than their federal counterparts, guarantee a minimum set of rights around the country while allowing kind of healthy state-level variation, promote federalism values, and also, I think, reinvigorate state constitutional law for some of the reasons that I suggested. So thank you.
Okay. Well, thank you for coming here. Thank you for having me. This has been a terrific conference, and I'm honored to be part of it. The paper that I'm going to talk about is part of a larger project that I've been working on for a few years. And as you can see from the title, what my concern is that we should have ideological balance. And the problem that I'm going to talk about is that our political system suffers from many what I call and other people call many winner-take-all features. The president, right, can win 51%, 52, 53, or 46% of the vote and get all of the presidential power. In Congress, at each congressional office, the person who gets the most votes gets all of the power. And then if you look in the House of Representatives, whoever's got the majority has all of the power. The Senate, with the filibuster, can temper that some. And the Supreme Court, whichever party, if right now we have a conservative 5-4 majority, and so on, close votes, winner takes all. 5 votes is enough to impose your view. And there are 3 problems. Sorry. Should be more specific. Okay. So 3 problems. When you have majority rule in the Supreme Court or winner take all in other parts of our government, you deny meaningful representation. And I say half the public because we're pretty evenly split between Democrats and Republicans. So the Republicans are now represented pretty well in the majority of the Supreme Court. Liberals, Democrats are not well represented. Same thing in the White House. If you're a Republican, well, I know there are divisions in the Republican Party, but you're much better off with the current president if you're Republican than if you're Democrat. And we'll contrast this, of course, with Europe, where it's not winner take all. There's much more proportional representation. So basically, I'm going to argue for a more European approach. Well, you deny meaningful representation to half the public. And if the Supreme Court really were non-political and ideology didn't matter, if Justice Roberts' analogy of balls and strikes were accurate, we wouldn't have to worry about it. But as we've heard correctly, politics does matter. Ideology does matter in the Supreme Court. And because ideology matters, we should all be represented, and we're not. So that's problem number 1. We deny meaningful representation to half the public. And that leads to a second problem that we've talked a lot about. when you deny meaningful representation, it really politicizes the judicial appointment process, because now each side wants to gain the majority. That's why Merrick Garland was blocked. That's why Justice Gorsuch led to all these television ads. We've got a highly politicized judicial appointment process because each side wants to get the majority. And that's not healthy to have such a politicized process. It's not healthy with our presidential elections, with all the money that flows in. So the second problem is the politicization of the process. It may go back 200 years, but it's persistent and it's getting worse. The third problem is it increases the risk of ill-advised decisions. I have my ideological views. I think I'm right, but I also recognize that I'm not always right. And I think it's important that both sides, there are truths on both sides, conservative and liberal, and people are misguided on both sides. And if you only have one side controlling it, there's no, they're going to promote their truths, but they're also going to promote their blind spots. And if we have both sides represented, we'll make sure that the conservatives on the court can steer the liberals away from their misguided tendencies, and liberals can steer conservatives away from their misguided tendencies. So I think you get better decisions. And there's lots of studies of decision-making, and what we know is that you get better decision-making when you have a diversity of perspectives coming to solve a problem. And I think we're better off with the Supreme Court, where both sides can weigh in effectively. I also think this is consistent with constitutional principle. Because as the framers, what they were worried about, or if you read Federalist Papers, Madison, chief concern was factions gaining control of government power and pursuing their narrow self-interest over the overall public good. And so the framers designed a system that they thought would block factional control. Unfortunately, it hasn't worked out because of the rise of political parties. They feared it. They hoped we wouldn't go that way, but we have. And what is a political party but a very large faction that does gain control of political power? And so we end up with a Supreme Court that's driven by powerful factions, which is what the framers didn't want. And so I think they would be very sympathetic to something to counter that. So how do we counter it? Well, I'm going to suggest, bringing ideological balance gives us three things. It ensures meaningful representation for everybody. Both sides are represented if you have ideological balance. We diffuse the politicization of the process. If neither side can gain majority control, there's no gain in trying to block certain appointments, because you're never going to be able to get a majority control. And as I say, I think we'll get wiser decisions, because I think diversity of perspectives gets us better results. So I think we're better off with ideological balance. And now I'm going to suggest three models. How would you get there? And I'm going to suggest, as I say, three models. So one is to get ideologically moderate justices. And this is an approach in some of the European countries. Try to get, instead of getting some conservatives and some liberals, try to get the John Paul Stevens, the Byron Wrights, the people more in the middle. A second way is to accept conservative and liberal justices, and that this is a reform championed by Eric Siegel, you'll hear more about, but to have a balance. So instead of having an odd number of justices, we'll have an even number, 4 on the conservative side, 4 on the liberal side. Or it could be 5, 5, 6, 6. One of the questions I need to follow up on is, what is the optimum? We have 12 for the jury. Should we have 12 on the court? But whatever the right even number is, it should be divided. So we have different justices can have their own, one ideology on the other side, but the court overall will have ideological balance. And then the third is to just focus on getting directly ideologically balanced decisions. And so the approach there, and again, you see this in some of the European courts, is to, rather than allow simple majorities to decide cases, require a strong supermajority or even consensus. That decisions have to be agreed by all people. And you see that in some of the constitutional courts in Europe, where dissents are rare, in some cases non-existent, in some countries that they operate on the basis of consensus. So those are the three approaches, and I'll talk about each one. So as I said, the first one, ideologically balanced justices. Instead of having conservatives or liberals, try to get people in the middle of the road. How would you do that in Europe? One way to do that in Germany, to get nominated to the Constitutional Court. And in Germany, like many European countries, they have a Constitutional Court which decides constitutional questions. Other courts decide other kinds of questions, unlike our system where all courts get to decide constitutional questions. So I'll talk about their constitutional courts. I'm glad to see Professor Tushnet here, who can weigh in on some of these issues. But in Germany, you need to get 2/3 of the legislature to approve, kind of like our filibuster, 2/3 vote. So that means you don't get approved unless you can appeal across the political spectrum. So that might be one way to do that here, and to say 2/3 vote for approval of a nominee. A second way to do it would be for the Senate to exercise its advisory and consent role and to set up a judicial nominating commission, much like we have in many states, and they would have Democrats and Republicans represented equally on this judicial nominating commission, and they would send nominees forward to the president. And if they made it clear to the president, we're only going to approve people that come out of our nominating commission, they could force nominees that way, and we'd get more, again, people in the middle of the road, John Paul Stevens, Byron Wright, and fewer William Brennans or Antonin Scalias. And of course, presidents already do look to guidance for nominees for the lower courts, for Senate. Wisconsin has actually a nominating commission that they've set up, federal nominating commission, that sends names to their senators to recommend to the president. An ideologically balanced court, as I say, you have 8, 10, 12, and half are Democrat. Well, I want to say half are conservative, half are liberal, whatever, but how would you do it? Because how do you decide, would Donald Trump really nominate a Democratic? Wouldn't he pick a conservative Democrat? So the way I would set it up is follow the judicial nominating commission, except you have two. One run by the Democrats in the Senate, one by the Republicans. When one of the liberal seats opens up, the Democrats get to send names to the president, and when a conservative seat opens up, the Republican commission gets to send nominees. And then New Jersey has something like this, not quite even Steven, because they have a 7-seat Supreme Court, but for about 70 years, this is not written in stone, it's a tradition, but at least 3 of the seats belong to the Democrats, 3 belong to the Republicans, and when the 7th opens up, the governor's party gets to choose the tiebreaker. Even number of justices, if you may work, you got to have a tiebreaker. There is not a tiebreaker in Germany. They have 12. Spain has 16. Austria has 20. Belgium has 12. Okay, so even numbers of justices, not common here, but common overseas. And then the ideologically balanced decision. We don't worry so much about who's getting nominated, but we make sure it's a supermajority or a consensus vote. And that way we make sure if you got to get all 9 justices on board, you're going to get some liberals, you're going to get conservatives. And so that's the simplest one. You don't have to make a lot of changes. European courts do this, as I said. And Justice Roberts said he wanted to do it. The court could do this on its own. The main disadvantage, how are we doing on time? 3 minutes to go? Very good. Okay, that should give me enough time. The main concern I have about the politically moderate justices, why not just get all moderates? The main concern I have about that is because it is good to have a diversity of perspectives. I think we're probably better off if we have a range across the political spectrum and force that range to come up with a consensus view rather than get everybody in the middle. I want to end up in the middle, but if everybody's coming from the middle, you don't have this as rich an input. So maybe for the district court, because there's only one judge there, have moderate justices, go for moderate justices in the district courts. When you get up to the appellate courts, have a diversity of viewpoint, and then go with an ideologically balanced court. And I would do both. I'd do a balanced court and a consensus or supermajority. And the reason why I want to do both there is because with one of the problems, okay, so you appoint, you get your 4-4 court. And as Professor Freeman mentioned, Harry Blackmun was supposed to be a great conservative, and he moves to the left. So now you've gone from 4-4 to 5-3. So by requiring the supermajority, you protect against the ideological drift. If you predict wrong that somebody will be in the middle, or on the left, or on the right, and they move over. But I want the ideological balance too, because I think a big advantage of that is if you just do the supermajority, it's still better to have more of your side than the other side. You'd rather have 6 conservatives and 3 liberals if you're conservative. Even if they have to all reach agreement, you want more on your side. So the ideological balance depoliticizes the process. Because again, you can never get more than your half, so why would you politicize the appointment process? The final point I'll talk about, well, why won't they gridlock? I think Professor Tushnet mentioned this morning, he doesn't have to update his case book because we don't have any important decisions from the past year where the court was deadlocked 4-4. I think that's right when you've got a temporary deadlock, and each side can delay and say, next year I may have the 5th. So why decide now when I might have a majority next year? But when you know that deadlock, that 4-4 or 5-5, whatever the even-steven balance, is permanent, you can't do that. You can't punt and hope for a majority down the road. You're stuck with your even balance. And what game theory tells you is that when you're in a negotiating situation with a group of people who you're going to have to work with over an indefinite time horizon, that gives you strong incentives to cooperate rather than defect, as they say, because, and finally, the Supreme Court justices are there because they want to leave a legacy. They're not interested in having a career where they didn't get anything done. They want to make a difference. They've spent decades maneuvering, and so I think they would find common ground in most of the time. So thank you for letting me be here, and I look forward to your questions.
You've almost made it. I stand between you and dinner. I have 15 minutes. I'm sorry?
Is it concluded?
Reception, yeah. I have 15 minutes to describe a fairly complex statutory proposal that I have made, and I'll try to do it. I talk really fast, so that's the good news about that. I'm going to take as a given that our system is broken. I think it obviously is. I think it is extremely likely that if the Democrats regain control of the Senate and the presidency, they will in fact stack the Supreme Court like FDR unsuccessfully tried to do. That is evidence enough that we'd even be discussing that our system is broken. So here's a proposal to fix a lot of what people have been talking about today. I like life tenure being abolished. I think that might take a constitutional amendment. Akil might be right about that. Mine does not. So the Congress tomorrow could pass a law that says the Supreme Court from here on forward will have 4 Republicans and 4 Democrats forever. A president can send over to the Senate anybody a president wants. That's his, I was so sure I was going to say her, but that's his constitutional prerogative. He can do that, but we're not going to take him. If a Democrat dies or leaves office, leaves the bench, then a Democrat must be sent over, and same thing for Republicans. Now, I have 3 subtle parts of that make it more palatable, I think, to a lot of people. First, if you change your political party affiliation in the preceding 5 years, then you have to get a 2/3 vote of the Senate because we don't want monkey business like that going on. Second, if you are an independent or you refuse to reveal your ideological partisanship, which almost no Supreme Court justice has done in a very long time. We've known all the Republicans and all the Democrats. But if you do that, that's fine. You have to get 2/3 vote as well. If a great independent comes around who's going to save our country, the Senate will vote 2/3 for that person. And then finally, and this is the most important one, this may help your issue, David. So if Justice Ginsburg were to leave the bench and my proposal was in play, and President Trump had to nominate a Democrat to get that person on the court, I would add a 3rd part of the analysis, which is that 2/3 of that person's party on the Senate Judiciary Committee has to approve of that person. So that if President Trump could find an incredibly conservative Democrat somewhere, good luck with that in this day, but if he could do that, that person still has to get 2/3 vote of the Senate Judiciary Committee, his own party, her own party. So that, all of those things don't make this plan perfect by any means, but I want to say for my remaining 13 minutes, or whatever I have, my plan has to be compared to our current state of affairs, not some idealized version of the Supreme Court. And our confirmation process is broken. So the first benefit of my plan is the confirmation process immediately gets improved dramatically, because we know there'll always be 4 Democrats and 4 Republicans. Now, if or maybe an independent who is super great, and by the way, if we get that independent, then the political party affiliation of the president it would be the one, or I'm sorry, the retiring justice would be the one that matters. So right away, the stakes go way down in our confirmation process, because we'll always have an evenly balanced Supreme Court. If I had more time, I'd go much deeper into that, but that's a very big advantage. But it's not the largest advantage. The largest advantage is that it makes it much more unlikely, it doesn't guarantee anything, but it makes it much more unlikely that we'd have a Lochner era, where from 1902 or so to 1936, the Supreme Court strikes down over 200 laws, most of which would be almost all of which would be easily constitutional today. Children wouldn't have worked in the coal mines longer than they did because of a terrible Supreme Court decision, and we wouldn't have a war in court. It would be much harder for the court to be on one far end of the ideological spectrum. It would make the court do less, probably. And that is a huge advantage. Another advantage is, and some people view this as a disadvantage, I think it is one of the best parts of my proposal. So here's my hypothetical. The Court of Appeals are divided, the circuits are split, and the Supreme Court is divided 4-4. That's our situation. What could possibly be better evidence that this is a situation where the Supreme Court should not impose a national rule than the fact that Wilkinson and Posner and Kaczynski and California and New York and Alabama have different rules. The justices themselves are divided 4-4. This is a hard issue. By hard, I don't mean hard under the text, because with Professor Tushnet, I don't think that exists, but it's hard in our political climate. And now, what are we going to do? Well, for the last 10 years, what we've said is Justice Kennedy gets to decide. That's what we've said. Because in something like 97% of con law cases divided 5-4 since Justice O'Connor's retirement, Justice Kennedy has been the deciding vote. That's a crazy system. That doesn't make any sense. If we have a lot of really smart people divided, then maybe Alabama and California should have different rules. And that's a long way, and that's a huge benefit, by the way. Now, some people say, oh my God, Professor Siegel, but uniformity of federal law, uniformity of federal law. We need a single rule. No, we don't. In fact, as we sit here today, 99.999% of cases never get to the Supreme Court, and 99.2% of federal cases never get to the Supreme Court. Translation, we don't care about uniformity 99.2% of the time. If we have a situation where uniformity is really, really important, and our country will perish without Justice Kennedy imposing a national rule on the rest of the country, a 4-4 evenly divided court will find a way to get there. No one, except maybe Professor Tushnet, is more critical of the Supreme Court than I am. Actually, I think I've exceeded you in recent days. But even I think that they are patriots and that they love their country and they love their court. And if the fate of all of that is going to go away if they deadlock, they will find a way. And we have seen some evidence of that in the Obama, not that the stakes were that high, but in the Obamacare contraception case, they were very, very much divided, that's obvious. But they found a way to send it back, and we'll figure out a way. One more thing about that, and I think this is a crucial point. We have hundreds of much more diverse people occupying the United States Courts of Appeals than we have in 9 people on the United States Supreme Court. When Justice Scalia wrote in his Obergefell dissent a couple of paragraphs that, frankly, I'm not suggesting this was on purpose, mirrored what I wrote in my book, which is our justices come from 2 or 3 law schools, they come from the coasts, they come from a couple of religions and so on. We have an incredibly non-diverse Supreme Court by almost any measure, except they're all Ivy League graduates. That's not true of a lot of, I mean, that's true for many lower court judges, but it's not true at all for the same percentage. And we even have, I think, some Court of Appeals judges who may actually have done some criminal law in their lives, something no Supreme Court justice has done, really seriously. Certainly no public defenders. And we don't have a lot of those, but the chance of that happening among the hundreds of Court of Appeals judges is a good thing. And I just want to repeat one more thing I said about that. When you have Judge Posner in Chicago and Judge Wilkinson in North Carolina and Judge Kaczynski in California really thinking about a politically controversial issue and disagreeing, that's going to be helpful, and that may in fact happen more under a 4-4 type of system. And I think that is a net good thing, because otherwise we get Justice Kennedy's rule. Now, I will say that Lee Epstein, who has done fantastic empirical work about the Supreme Court, has lectured me now on several occasions when I've made this presentation, saying Justice Kennedy is an anomaly. And that may be fair. Well, I think he is statistically an anomaly. But is he going to be an anomaly going forward? I don't think so. The cries of no more Souters and no more Kennedys are going to impose upon the Supreme Court, I think, forever until something dramatic happens, a kind of 4-4, rigid thing with probably somebody fairly conservative in the middle, until maybe we'll get somebody somewhat liberal in the middle. But I think the median justice is going to play an important role. Certainly Justice Kennedy has played a role that really no person should play in any democracy. This man has life tenure and is the literal deciding vote in scores of unbelievably important cases, not necessarily because of their actual practical effects on the ground, but they define who we are as a country. So if Justice Kennedy had changed his mind, abortion law would be different, affirmative action law might be different, the voting rights case would be different, which would be a great thing. That's a different conversation. And I could go down that list over and over again. Doesn't make any sense. Justice Roberts said last month in Kentucky, he was in Kentucky giving a talk, and he said, since Justice Scalia passed away, we've worked harder at our conferences. We've debated a little bit more, and we've tried to get more consensus. Well, that's a great thing. And that's what it's a little known thing that they actually never debate, not orally. They debate by memo. I think it is still memo, not email, which is incredible. But leaving that aside, they don't actually get together and hash it out. And Roberts said, we're doing just a little bit more of that. Well, they should do a lot more of that, and maybe if they were 4-4, they would have to. They would issue more narrow decisions. They would act in what Cass Sunstein would say is a more minimalist fashion. And all of this is a good thing for a life-tenured court whose decisions in the cases we care about, there's been so much misinformation recently, that may be the wrong word, propaganda, and Gorsuch was one of the purveyors of this, that the court agrees so often. No, it agrees when very few people care. When people care, they're almost a lot. They're almost never unanimous. And what that translates to is a divided country often on issues like abortion and affirmative action and church-state and so on. And what that leads us to is what that has led us to, certainly for the last decade, is rule in many cases by Justice Anthony Kennedy. And my proposal makes that, well, impossible, because they'll be 4-4. On the uniformity point, just one last thing about that. We all want our rules. I want pro-choice politics in all 50 states, and I happen to like affirmative action, and I have the typical liberal progressive bent. I want those rules everywhere. But if I had to make a case that uniformity required my rule, I've tried. I couldn't do it. And the fact is that if Alabama and California and New York have different laws, then that's not going to impede any uniformity interest in those cases. Now, there could be some statutory cases involving antitrust and maybe securities regulation. And there might be some other constitutional law cases involving the Dormant Commerce Clause, those dreaded 3 words, and you know, economic areas where we really do need uniformity. Otherwise, our economy will get much worse. If we need that, A, the justices might find a way, B, the Court of Appeals might find a way. So if if I'm a big corporation and I want uniformity, or I'm the federal government and I've won in 2 circuits, and now I'm arguing to the 3rd, and we know forever the Supreme Court is going to be 4-4, then I might argue, don't take the chance of the court dividing. Our rule might not be your ideal rule, but the need for uniformity is better than your preferences. That kind of argument occasionally works. And so I don't think, if you're going to object to my plan, I don't think uniformity is a great basis for objecting to it. So I want to just remind everyone that this proposal of having a permanent 4-4 Republican, Democrat with an occasional independent possibly thrown in proposal, we're not comparing this to a system everybody is happy about. We're comparing this to a system that many people think is either going to be broken soon, is broken now, or at the very least violates a cardinal rule of democracy. Never, ever give somebody largely unreviewable power for life. That's a terrible idea. And my proposal doesn't do away with all of that because they still have life tenure, but their largely unreviewable power will at least be somewhat diminished. And that's my suggestion for reform for the Supreme Court of the United States. Thank you.
I have a lot of notes here. All right. Well, we have a good amount of time. My notes fall everywhere. For questions, my encouragement would be to keep your question relatively short, so that and to direct your question to a particular panelist, and then we'll see if another panelist wants to jump in.
Can I ask Eric a quick question?
Please.
Just as clarification, Eric, so 4-4, and Justice Kennedy is on one side, and then you have 4 on the other. Doesn't that empower one of the other guys out of the other 4 to now play this old role that Justice Kennedy was playing?
There's no way in any multi-person body, I think, to change that. But it will certainly make it, in any case the Supreme Court decides under my proposal, one Republican has to agree with at least 4 Democrats, or one Democrat has to agree with 4 Republicans. I didn't get to it because I didn't have time. There are enormous benefits to having that, especially in our current world, to having that bipartisan requirement. And I think Justice Kennedy has kind of proven that, given all the controversy he's engendered, we still accept him. And I think part of that is that he was, a Reagan person, and he's now siding with Clinton people, and I think that's some, sugarcoating for some people.
Mark.
So one sort of tweaky kind of observation for both David and Eric, and then one more analytic observation for Eric. The tweaky suggestion is both of the proposals are predicated on there being 2 permanent parties. And in Germany, with the 2/3 requirement, Germany has a proportional representation system, but it's got a very high threshold. So it generates 2 parties, except you've got the Greens. And with the rise of the Greens, they had to figure out how they were going to tweak their system. Now they did. They figured out a way. Eric, you've written in Democrat and Republican into your system. And that might be a problem if what happened to the Whigs happens to one of the current parties. I don't think that's insurmountable, but they're, okay. The analytic point is on the 8-to-8, on the 8-person court, there will be, this is the technically correct term, but there'll be selection effects about who wants to be a justice on that. Now, you're a big deal when you walk into the room. You know, people scrape and bow. And, you know, walk into the room when you're in 8-justice court and not doing all that much. I'm in favor of they're not doing all that much. But the people who want to do that are now people who maybe sort of want to be Court of Appeals judges or district judges or actually, you know, they have sort of low, medium to high level law practices.
Can I respond real quick?
I have two observations. One is, we know that there have been some people who became Court of Appeals judges because they thought it was a stepping point to going on to the Supreme Court. We know that because the most prominent one is Michael Lustig, who, when he lost out, he left the bench. Okay, so that kind of person actually now you have a knock-on effect on the Court of Appeals. The other is just an anecdote. I once had a conversation with a Court of Appeals judge, who had been a trial judge in Cleveland, I think, and asked why he became a federal Court of Appeals judge. But the hours were much better, you know. So you get different kinds of people because the nature of the work was different. I think that's good, but it's working.
I just want to say real quickly, I was telling Michael McConnell earlier today that, frankly, you and he were two of the biggest imprinters on me, because McConnell wrote back in the 90s a lot of articles about humility and how the one characteristic that he thinks might be most important for judges, especially Supreme Court judges, is humility. And Mark, to the extent that this role would be reduced, I think we have a big humility problem on the Supreme Court. To the extent their roles would be reduced, I think McConnell's wish for greater humility would become more realistic.
Yeah, on the two parties, it's possible we might, because we don't have the same two parties we did in before 1840. But since about 1840, it's been pretty stable. And political scientists would say it's because we have winner-take-all elections. That you don't. It's very hard to get a viable third party when you have winner-take-all elections. So until we get to proportional representation, I think it's pretty likely the Democrat-Republican two-party system will persist. The other thing is on the selection effects. Here's where, as I say, I don't think they would decide fewer cases. I do think that, as I say, the fact that they know it's a permanent 4-to-4 split and the fact that they do want to leave their legacy will drive them to compromise. They'll find a way to find a middle ground. And as I say, that's what game theory tells you, that when people are in a relationship where they have to work with each other or not work with each other, if they're going to work together on a regular basis, it's not a one-shot thing, right? When I go buy a car, the car dealer assumes I'm not going to be back for 10 or 20 years or maybe never, so they try to exact as much as they can out of me. But when I go to get my car serviced, Pat knows I'm going to come in every few months for my oil change, and he doesn't try to exact whatever he can out of me. So they're going to have an ongoing relationship, frequent interactions. And the other thing is it's an indefinite time horizon because they have life tenure. There's an advantage of life tenure. So they know that they're going to be with this person who knows how long. So, you know, they know when the term comes to an end, well, now I can screw that person because our relationship's ending. So there are a lot of reasons. And the final thing I'll say about it, why I don't think the role will become less important, it goes back to what Tocqueville observed, at 150 or so years ago, which is that as a society, we take our major social issues to court. And that's not true in other countries, but we do rely on our legal system. And I don't think changing from a 9 justice court to an 8, 10, 12, or 16 justice court will change that part of our societal ethic.
Other questions? I've heard two suggestions here that Congress might act in ways that would shock me. I think I've heard a suggestion there might be court packing, and a suggestion that seats might be eliminated when they come open. I presume only when they become open. We do have the midnight judges, but when they come open, and you know, I'm wondering. I think Eric made one, Richard made the other. What perhaps? What do the other panelists think of that, or do we have comments out here?
I didn't think I made one of those suggestions.
Oh, I thought you made a suggestion about eliminating seats.
Well, I think
No, I said it was done. I said it was done, that's what the Reconstruction Congress did when Andrew Johnson made the nomination. I wasn't advocating it. I was just saying that was more extreme than what the Republicans did to Judge Garland. The Republicans just made sure that Johnson wouldn't get a nomination by eliminating the seats.
I feel much better. that you
Yeah.
didn't
No,
propose
I
court
didn't.
packing.
I think
Yeah.
the political pushback, again, we're 50-50 country, so one party's going to alienate half the public, and just like FDR couldn't pack the court, I'd be surprised if that.
Well, let me just say that I have progressive friends who 5 years ago would have unequivocally said, we would never, ever, ever put forward such a proposal. I think in the next I think it is extremely likely. I've talked to people who would be in favor of such a proposal.
Oh, I don't doubt at any given time, half the public will support that. I just think at any given time, half the public will oppose it, and we won't get it done.
So when it was proposed, when FDR at the height of his power proposed it, he got knocked back in a favorable Senate, and the Judiciary Committee said this should be rejected so soundly that a similar proposal should never be presented again to the free representatives of a free people. And they tried to make that as clangorous as anything could be. And golly, maybe people will try, but I have a feeling that 1937 is going to hang very heavy over that, and the fact that it's been 150 years that we've had nine justices. And then the feeling is also, if you pack it to 15 or 12, whatever, then what happens when the Republicans get back? It's going to be repacked. I think there'd be tremendous resistance to it.
So just a quick comment. It does go to both David and Eric with respect to Mark's question about congressional power. David, you have some other things besides eight-member court or even number of justices. You had talked a bit about supermajority decision-making, perhaps issuance of no dissents as being a part of this package. And I'm wondering, does Congress have power to, say, mandate that? And if so, where in the Constitution? And then I also wonder about let's say you have a statute, which I hear is what Eric is proposing, and I guess you too, David, 4 Republicans, 4 Democrats. Are we comfortable that that's okay under the First Amendment?
Well,
Sorry,
my
what
question
part is on
also
the
is
first?
how could a statute limit who the president could nominate?
It can't. I said the president can nominate anybody, just won't get confirmed.
Because of a statute?
Well, no, the Senate would say, so here's the thing. The Senate has informal norms that it has followed for a very, very long time. My proposal could be done informally, for that matter. I mean, and the filibuster was effective, for a century. It still is effective for legislation, theoretically. The blue slip process you heard something about is still in effect, theoretically, because they agree to it. The minority party has agreed to this over the centuries. The majority party has agreed to this over the centuries because someday there'll be a minority party. So I just want to say one more thing about that. If Ted Cruz were here, I would shake him and say, you have to be in favor of my proposal because it reduces the power of the Supreme Court, it improves states' rights, it gives state Supreme Courts much more autonomy, and so on and so forth. But the truth is, it makes Congress and the president stronger relative to the president. So it's in their interest to follow this norm.
Yeah, on the nominating, if you really want to force it, you'd have to do a constitutional amendment. But the Senate could, as I said, set up a nominating commission to implement any of these and say to the president, if you want us to vote your nominee, you have to follow our recommendations. And if they're willing to, stick together and block the president. On Jason's question about the supermajority, this is something I want to, Article 3, Section 2 says, Supreme Court exercise its jurisdiction under such regulations as Congress shall make. So to the extent you go with constitutional text, they could do that.
Well, so how does that play out?
So now whether, I guess they would just amend the Judiciary Act of 1789 and say, you've got to make your decisions this way. I think the main argument, or at least one argument, would be a separation of powers argument.
But it goes to jurisdiction, right? So Congress can create exceptions to the court's jurisdiction. Yeah. You're talking about a case that is before the Supreme Court, and then some additional requirement that it be decided by a supermajority. How does Congress get to that via this textual language?
That's a rule for the court decision.
Right.
It seems to me textually it's possible. But we had a question here.
For Professor Friedman, you mentioned Roe v. Wade, and I can't understand how overturning Roe v. Wade would help us progress as a society. And so I was wondering if you could explain that. And also, what about the progeny of other right to privacy cases, rights to privacy, etc.?
So, okay, let me address the last part. I think it's very interesting how, take for instance the president's response. He said that Obergefell, he said that's decided, no desire to undo that, and that would include Lawrence, of course. And so it's very interesting how in this last election, even though Obergefell was such a recent development, even on the Republican side, there was very little disposition to try to undo it. And I think that's because there's been enormous acceptance over the last couple of decades of the fact that there are people who are not heterosexual, okay, and that they should have full lives. So I think whether it should have happened the way it did or not, I think people said move on. Roe is a very different thing. The political cleavage is about where it's been for the last 45 years since Roe. So as I say, I can't think of another decision that comes close in the degree of hostility that it creates. And I should say, I'm personally radically pro-choice, okay, in the sense that I think the legislature just shouldn't get involved. But what you have in Roe is a lot of people who think that abortions, some abortions are murder or akin to murder. And so it's giving no sign of going away. So you look at what the situation now. In many states, access to abortion is not good at all. There are 6 states in which there's only one provider. Some big states, North Dakota, South Dakota, okay? So that means if people in many places want an abortion, they're going to have to go somewhere, some distance to get it. So what happens? Now I realize, there's some states that have laws that would immediately kick in if Roe were overturned. But you have to look at the dynamics of the situation. And what I'm saying is that, the old line about there's nothing that, like the prospect of hanging, that so focuses the mind. To a large extent, Roe, and there's debate over how much, but I think to a considerable extent it kind of kick-started the pro-life movement. And every time that Roe is seen to be in danger, fundraising increases. So if Roe were overturned, I think the political landscape gets immensely changed in that respect. I think in a sense the pro-choice movement has become too lazy politically, because it's an expectation that the court is going to handle it. So there's an enormous amount of money, and then you have legislative elections fought over the abortion issue, and when they're fought over the abortion issue directly, pro-choice wins in most places. And there's money left over to move those people who need to move.
I am radically pro-choice, met my wife through Planned Parenthood, worked for Planned Parenthood. He's right, and he's right for, we don't have time to go into it, but even more reasons than that. And for every issue progressives care about other than abortion, Roe has been one of the greatest disasters of all time.
He's
And
getting
in
a
the
lift to the
Casey.
airport from me, so he had to say, he
And-
felt he had to say that.
And many people heard the concurrence in Casey as, "Shut up," they argued. Other questions? Yes.
So Eric and David, I was circulating, so I didn't hear your full proposal, but you know I'm sympathetic to a lot of it, as I wrote in the New York Times. Although I was more for it as a temporary expedient, as a long-term solution to the politicization of the court, I'm a little bit more skeptical, and this is why. I think it sort of legitimizes the notion that, you know, constitutional interpretation can be mostly politics and not law. And I think it will breed a lot of cynicism in the American public about the role of the Supreme Court. So let's say that you get, you know, your 4-4 balance. Well, let's say you have a Justice Brennan on the Democratic side who can woo over you know, one or two on the other side, and you know, all of a sudden the decisions start flowing one way, and the whole American public is like, you know, this is just a complete political game. And so, while I was saying the temporary expedient of 4-4 in terms of minimalist decisions was not a bad thing, in the long run, I'd like to see us focusing on changing the culture of constitutional interpretation to minimizing the political elements and, you know, elevating, deciding upon objective principle bases. We had the Canadian Supreme Court Chief Justice here speaking about 6 years ago, Beverly McLaughlin. And I asked her, I said, you know, we have all these partisan 5-4 decisions on these very important cases, and I think it's ridiculous that we have King Kennedy, you know, as you just said, have been talking about. And I said, what about in Canada? How does this play out? Do you have this partisanship on the Canadian Supreme Court? And she said, you know, in a very small way, but in most of our cases, we try very, very hard to minimize any sort of political elements to our decision making, and I think we're successful. And if you take her at her word, it is a very cultural thing. And my preference would be to sort of change the culture, have the Senate try to change the culture through the confirmation hearings. And so I'm just interested in your responses as to sort of that, in Mark's issue about, you know, ingraining a two-party system, which is nowhere in the Constitution, and it's just elevated the, you know, political rancor in our country. So how do you respond to that? You know, how the promotion of cynicism?
I have two quick responses. One is I wrote an entire book that said the Supreme Court would be a lot better off if it adopted a hugely deferential approach and only struck down state and federal laws when, in Holmes's words, those laws made them vomit. So an incredibly deferential court could solve some of that problem, but that's not happening anytime soon. Second, and real quick, Neil Siegel at Duke, who's a great law professor, but once said something to me that blew me away and still does to this day, said, Eric, even if I agree with every descriptive account you and Professor Tushnet and other realists have ever written about the Supreme Court, why would you want to tell the American people that? And my answer was shock, and this is not going away, Barry, so we might as well admit it, and then let the people decide if they want that kind of institution.
Yeah, I'm very
So-
Madisonian about this, and that is,
Be very quick, though.
I think we should appeal to be you know, do the right thing, be virtuous, but the reality is people don't respond. They respond to the structural incentives they have, and our winner-take-all politics gives incentives to try to impose your view, and unless you change the structure so that you can't impose your view, that you have to find common ground, that's what you need. So the two things I said are the 50-50 balance or require supermajority, consensual, as in Europe. That's what they do. The constitutional courts there operate by consensus, and they decide issues, and because that's but unless you change the structural rules, people are going to pursue their interests.
Well, thank you. I think that has to be the final word. Please thank our panel.
So we started this symposium. The idea was to explore whether
all of the recent events swirling around the filling of Justice Scalia's seat indicates that we've sort of come to a crisis point in the politicization of the Supreme Court. And so we asked if you know, it has become too political. Perhaps it isn't the court that has become political. Perhaps it's external political pressures that are driving that. Perhaps it's not too political because it's inherent in constitutional decision-making. And if it is too political, what we can realistically hope to achieve to change that. And I'm just really pleased and honored that we had so many distinguished and thoughtful speakers here today. I don't think we answered those questions, but I think we got a lot of great insights and a lot of material to think about to carry us further down the road in terms of thinking about these important issues. So I just want to end by, first of all, thanking the participants and the great speakers that made this symposium great, and I'd like to give them a round of applause. Secondly, I'd like to thank our faculty who served as moderators for the panels. Thank you very much. And last but not least, I'd like to thank Alice Anderson, our Law Review Symposium editor, Helen for supporting this symposium, Derek for doing the great IT work associated with this symposium, Suzanne Inman, our events director, for in conjunction with Alice doing a lot of the heavy lifting in terms of the logistics, and they did an excellent professional job, which I really appreciate. And I'm sure I'm forgetting others, but in our Pepperdine staff and on the Law Review, a hearty thanks for all the hard work you did to make this possible. And now I'm going to turn it over to Alice to make some brief closing remarks on behalf of the Law Review. And then, as I said, I hope to see you at the reception. Thank you.
On behalf of the Law Review, I echo all of Professor McDonald's comments and thanks to you, to our participants who came and prepared, put in hours to speak, to our Law Review for help in preparation, and to all of the event staff and the tech staff and people who gave hours of their time to come and have this conversation. So we thank you so much for being here. Just two housekeeping issues. If you're here for MCLE credit, I'm going to stand here in the front for the next few minutes, and you can bring me, I think it's your activity sheets, and you'll be able to pick up a certification sheet at the front registration table where you first signed in. And the second is, if we hope all of you come to the Duke's reception. It starts essentially whenever you want it to. And for those participants who would like a shuttle there are shuttles waiting outside of the School of Law, so you can go and grab a shuttle over, and they'll be available throughout the evening. So we look forward to getting to know each other more at Duke's and hope to see you there.
Do you want to tell them, for those driving, how to get there?
So for those driving, I typically use Waze, it's south on PCH, I think probably about 4 miles on the right.
You can't miss it.
You really can't miss it. It's one of the only big restaurants on the beach side of PCH. So we look forward to seeing you there.
Thank you.